So what is it that the CISG requires in order to have a valid contract? Well, most importantly, a valid contract under the CISG requires mutual assent. Now, in any sales transaction, there's going to be a buyer and a seller. And before the contract can come into existence, there must be an offer and an acceptance. Before becoming buyer and seller, the parties are identified as offeror and offeree. And either party can be the offeror or either party can be the offeree. There was not a direct correlation. So mutual assent means essentially there is an offer and there is an acceptance. So formation of a contract occurs when the offeree accepts an offer by the offeror. That's mutual assent, offer and acceptance. If the offeree, the party receiving the offer, decides to accept it, the offeror then becomes bound to the terms and conditions of the offer. So mutual assent creates a valid contract. Mutual assent is made up of an offer and an acceptance of that offer. That's when we know a contract has been reached. Mutual assent requires both the offer and acceptance. Now, in the common law and in the UCC, we also have the requirement of consideration. You may recall this from your introductory business law course, that we know a contract is formed when there is offer, acceptance, and consideration. Consideration means something of value is being exchanged. The CISG has no provisions requiring consideration. There is no need for value to be exchanged. The parties simply have to agree between themselves. And this reflects the civil law provision of contract formation. This is one of those areas where in the civil law, a court or an arbitration panel will not look for consideration. In the common law, in a common law jurisdiction, the court may well look for consideration even though the statute doesn't specifically require it. It only requires mutual assent, offer and acceptance. Now, sometimes it can be hard to tell whether an offer has been made or not, and what were the terms of that offer. Now, the CISG reflects the understanding that many sales transactions can occur in a rapid and casual way. In one single phone conversation, there could be offers, rejections, counteroffers, and a rejection of the counteroffer. And eventually, the parties may agree to accept the offer. And again, the offer can be made either by the buyer or by the seller. Article 14 describes what is a valid offer. In order to be a valid offer under the CISG, first of all, it must be addressed to one or more specific persons. The offer must then be sufficiently definite to indicate the goods and factors like quantity and price. And we can either determine quantity and price from the express terms of the contract, or they could be based on things that we could implicitly decide. Finally, it must indicate the intention of the offeror to be bound by the proposal in case of acceptance. So how do we do this? For an effective offer, the key issue is, was the offeror intending to be bound by the offer? And we decide that question by looking at two different components. The first is the number of people to whom the offer is addressed. And secondly, how definite is the proposal? Who is the offer sent to, and how definite is that offer? How definite are the terms of that offer? Is an advertisement an offer? The answer is generally no. They are not considered offers because they are not addressed to specific individuals. So if I mail a brochure to 1,000 different businesses, including an advertisement for a toolkit that my company sells, it's not an offer. It's an invitation to make an offer. And so the recipient of that catalog or that brochure can then contact me to say, I would like to order a toolkit. They then are the offeror, and I, the manufacturer, am the offeree. I have not made an offer. I've simply extended an invitation to make an offer. How will this look on your test? Well, here's a hypothetical. German seller sends out a catalog to 2,000 companies on a mailing list that it obtained from another vendor. And the mailing list identifies buyers who have purchased industrial equipment in the last 2 years. The catalog includes this toolkit valued at $50. An American buyer sends in an order for 50 toolkits. Is there a contract? No, because that was not an offer. The mailing item was not an offer. Instead, the offer was from the prospective purchaser, the American buyer. If the German seller simply ignores the offer, it is not bound to the terms of the agreement because its original offer was not addressed to specific persons. It's not a valid offer for finding the existence of a contract. Same sort of facts, except this time the German seller tells the American buyer, we'll give you a discount if you order a large quantity of the toolkits. The American buyer responds by sending in an order for 100 toolkits at $45 each. Is there a contract? Again, no. This time the buyer is identified, but the offer was not sufficiently definite. We don't know what a large quantity means. We don't know what is the size of the discount. So without those specifics, it is not a valid offer. Effectiveness of the offer. How do we know when the offer becomes effective? The CASG, Article 15, says an offer becomes effective only when it reaches the offeree. Until the offer reaches the offeree, the offeror, I say the seller here, but it's either party, has the right to withdraw the offer before it reaches the offeree. So I have the right to withdraw an offer at any time before it reaches the offeree. Even if I've said this offer is irrevocable, I will hold this offer open for 15 days. If I withdraw the offer prior to the time it reaches you, then I can do so, even if the offer purports to be irrevocable. The offer doesn't become effective until it's received by the offeree. If I send an offer by 2-day delivery, I have those full 2 days to notify the offeree that I am withdrawing the offer. I have the right to do so because Article 15 says the offer is not effective until it reaches the offeree. So look for a question like that on your test. Can I withdraw the offer after it has reached the offeree? The general rule says I can revoke my offer. I can pull my offer back at any time before acceptance. The offer is revocable when it reaches the offeree and before acceptance. The seller, the offeror, has the right to withdraw the offer at any time before the offer reaches the offeree, but also has the ability to withdraw the offer at any time before acceptance, even if, before acceptance. Now, once the offer has reached the offeree, the offer may become irrevocable. It doesn't have to. I can offer to sell you 50 toolkits at $50 each, And until you accept that offer, I can revoke my offer. I can withdraw my offer at any time. I, however, have the ability to say, I will hold this offer open for 15 days, or 2 months, or 6 months. An offeror can make an irrevocable offer. Now, in the UCC, this is called a firm offer. Now, the UCC permits firm offers, but there are a number of requirements involved. It must be in writing, there must be a signed writing, and in fact, the time limit is no more than 90 days. The CISG does not have any of those requirements. The common law doesn't even allow for an irrevocable offer unless there is consideration paid. It requires the payment of consideration to hold an offer open. It can be withdrawn at any time. Under the CISG, firm offers are valid even when they are not in writing. So, under the CISG, if a party extends an irrevocable offer, the offer remains irrevocable, regardless of whether there's been a writing or any money paid to hold that offer open. A rejection of an offer terminates the offer. So an offer is terminated when a rejection reaches the offeror. Even if the offer was an irrevocable offer, once the offer is rejected, it is terminated. If I say I offer to sell you these toolkits at $50 each, I'll hold the offer open for 10 days. If you notify me on the 5th day that you are not going to accept the offer, and I say, fine, I'll consider the offer terminated, even if they call back on the 7th day, the offer is off the table. The offer is gone. The rejection has terminated the offer. The acceptance. How do we accept? Well, CISG Article 18 says that a statement made by a party can indicate assent to the offer. That's an acceptance. Or any conduct of the offeree that indicates assent to the offer as an acceptance. So if you are the buyer and you send me an offer for the purchase of certain goods, if I ship those goods to you without expressly accepting your offer, it may still be an acceptance. There are two elements to acceptance. There must be assent to the offer, and that could be an express assent, or it can be implied assent by shipping the goods. And then you must communicate that assent. I must send a notification that the goods have shipped. That's enough to form a contract. Once the assent of the offeree reaches the offeror, the contract is formed. When is acceptance effective? It differs from the common law. Under the common law, acceptance is valid on dispatch, meaning when the acceptance is sent. You may recall this from your introductory business law course, known as the mailbox rule. Contract is formed when I put the letter in the mailbox, when I send the letter by FedEx, when I send my assent by an email. When it is sent under the common law, that is an effective acceptance. The CISG does not recognize the mailbox rule. Under the CISG, an acceptance is not effective on dispatch, but only when it reaches the offeror. And what this means in a practical sense is the offeror has additional time to withdraw or revoke the offer. The acceptance is not valid until it reaches the offeror. So if a seller calls a buyer and offers to sell toolkits for $50 each, the seller says acceptance must be in writing. The buyer thinks about it and then the next day sends by 2-day delivery an acceptance. The seller has the right to withdraw the offer at any time before that acceptance reaches the seller, the original offeror. no contract is formed. So again, look for a question like that on your exam. Acceptance is not effective unless it reaches the offeror within the time fixed, or if no time is fixed, within a reasonable time, taking into account the circumstances of the situation and including the idea that communication often happens rapidly.